The damage I'm claiming is $7,138.17. Lesser deposit, 1,050. So the balance, 6,000.
Today we are diving straight into a courtroom moment that instantly raises eyebrows. A damage claim of over $7,000 is dropped right at the start, setting a tense financial tone. But the real intrigue begins when confusion over the security deposit surfaces almost immediately. One side believes everything was already settled, while the other is clearly pushing for more. This clash of expectations creates an immediate sense of conflict. The judge steps in calmly, but you can tell the situation is already complicated. It feels like something important was either misunderstood or ignored. That uncertainty hooks your attention right away. From these opening seconds, it's clear this case is headed toward something much bigger.
$88.17.
Ms. Norman, your position on this is all of that was waived in the previous proceeding.
And also my security deposit, that's an incorrect amount from my standpoint.
But as I was to understand this from before, and I certainly will have a trial on the issue, but I don't think it's going to be necessary. He was going to keep the security deposit, but there were going to be no other claims.
No,
No? Go ahead. What did you think was going to happen with the security deposit?
well, I did on that day in October of 2024. After that was over, I did submit an address for him to send my security back, my security deposit back. And then I got the damages. Yes. I actually thought the case was over from that day moving forward as far as any claims, since he did waive those in this court. But yes, I was definitely under the impression and that I would have my security deposit returned.
Is the amount that you're claiming, is that rent?
No, none of it is rent. I waived the rental dollar amount that we had talked about previously.
Have you sent to Ms. Norman what your claims are for security?
Yeah, she's gotten
Well,
documentation on repairs and just showing all the damage and all that.
and all of those have been done?
Pardon me?
All of those have been done?
Have been repaired, yes. That was all repaired before a new tenant moved in.
When did you move out?
October 31st of 2024. I moved in March 24th. 2020. And respectfully,
Go ahead.
Mr. Stanford, there were several issues with the property, which I reached out to Hisville Township, to Frank Daniels, and asked for inspection, and that was,
Because he didn't have a COC.
well, because the property had leaks
Right.
everywhere, so I reached out, because Pittsfield Township said that I could do that as a tenant. And that's when I found out he didn't have the certificate of occupancy and all of the repairs that needed to be done. And I do have that report with me today.
Which report?
The report from Pittsfield Township with all of the uncorrected issues at the property.
So it would seem to me, as I look at all of, I have the transcript from the October 22nd, 2024 hearing. And part of the issue that I see is that there came up this water bill and some other things, but you never had a certificate of compliance on the property.
Because of a oversight on the Pittsfield Township Building Department.
But you didn't have a COC.
I did when she first paid about $4,000 towards the initiation of the lease.
Do you have proof of that?
Yes.
You have it with you?
Yeah. The
But then it expired.
pardon me?
Then it expired?
And then it expired. Because the township failed to do what they are required to do by statute, sending out a letter initiating the process of renewing the CFC is what they call it.
But she paid rent while you did not.
The tenant confidently insists that the previous case resolved everything, but the landlord moves forward with new damage claims, creating a clear contradiction. This disagreement becomes the first major crack in the case. Then the judge introduces a critical issue, the certificate of compliance. Suddenly, the focus shifts to whether the landlord was even allowed to charge rent legally. The tone becomes sharper as the judge starts probing deeper. The landlord attempts to explain, but the responses lack strength. Each answer seems to raise more questions. You can feel the judge beginning to challenge the foundation of the claim. At this point, the case starts tilting.
Not have a certificate of compliance.
She paid money.
No.
Yeah, she paid the money
right.
during that time.
She paid rent while you did not have a valid certificate of compliance.
Yes, and that was
How much did she pay when you did not have a COC?
the I submitted that to the court of the payments that she made. We get a comment here.
I have to let him.
She had paid. Well, Your Honor, I object to this. Let me just.
You can object all you want. It's my question. Overruled. Answer my question.
All right, she paid on May 1st, $2,000. On May, or it's 2024, May 13th, she paid $2,000. On May 13th, 24, $231.01. And on May 28th, she paid $2,000.
And all of that time she paid, you didn't have a valid COC.
Because of the failure of the
Didn't ask that.
Pittsfield Township.
Did not have a valid COC.
That's correct.
And you understand without a valid COC, you can't charge rent.
Well, there is a court case, Norton versus Southern Utah Wilderness Alliance, 542 US 55 in 2004. An agency action unlawfully withheld or unreasonably delayed. A claim can proceed only where the plaintiff asserts that the agency failed to take discrete agency action that is required to take. They were required to start that process of
Okay,
COC.
but that's your claim as against, that may be your claim as against Pittsfield,
That's true, but reasonable decision.
but you can't, but you can keep going with the law with me if you want. We can go for, I can go for days. That pertains to your claim if you had one against Pittsfield.
I understand what you're saying.
Okay.
Let me continue here. Procedure of due process must be evaluated using a balancing test that accounts for the interests of the affected individual. The interest of the government is limiting procedure burdens and the risk of erroneous curtailing individual interests under the existing procedures, as well as how much additional procedures would help reduce the risk of error. I've already forego $19,000 in rent, and I don't believe.
What was I supposed
Township,
to take? What was I supposed to take from your reading of that?
that the courts cannot use the failure of Pittsfield Township as a burden against me failing to have this thing renewed. If they had done their job, I would have had the process going to have this renewed. They failed to do that, and I should not be pay the burden of that they failed to do their job.
As to whom?
As to me, should it be totally on my shoulders?
Hold on a second. Hold on a second. But the burden is not just yours, it is also Miss Norman's, isn't it?
Well, when you say burden, I'm not quite sure what you mean by that. They failed to do their job. It put me in a catch-22 situation where the C of O expired, and I wasn't aware that it was about to expire. And now,
how would you have had notice that it was about to expire, since they expire every 2 years?
I would have known that if they had.
No. You would have known that from the first one, because the law, it expires every 2 years.
That's the way it goes. Yes, but the procedure.
So why wouldn't you have been placed on notice that it expires if it expires every 2 years? Why do you need a notice from Pittsfield to tell you that?
Because it's something that for 35 years I've been a landlord, and that's the procedure that these government agencies do.
But you know that it expires every 2 years.
And I was not paying attention to that.
And okay, and that's a different thing. You weren't paying attention. Moreover, with or without the notice that they would send, you could have initiated the renewal of that COC.
I could have. I was
In
busy,
fact, if you were paying attention, you could have done it.
and I was busy preparing this property for re-rental, doing maintenance and repair works and getting it ready. So I was quite occupied with that. I wasn't. I didn't.
Yeah, but that's you. That doesn't mean that you couldn't have done it.
That's true.
So why then would that case that you cite be applicable? Because it's not just your burden, it also becomes Miss Norman's burden if Pittsfield didn't do what they were going to do.
I guess you could say it's both of our burdens. Because it put both of us into this situation. You know, she wouldn't let me come in and do the repairs. I couldn't, get the C of O inspected, property inspected to comply with that ordinance. And that's why at that time it stretched on for.
So you were trying to do the repairs because you had to get the CO.
I was trying
Who
to
you
get
had to get the CO.
the inspections done.
Regardless of whether or not Pittsfield sent the notice, you knew that you had no CO.
No, at the time I signed the lease, no, I did not realize that. It wasn't until after,
Why didn't you realize that?
because I was busy with the prepping that before she moved in. And then after she moved in, I was occupied with some of her complaints and demands.
That doesn't make any sense to me. If you applied for the certificate of occupancy 2 years prior, or at least it was renewed 2 years prior, why wouldn't you know that you don't have the CO?
Because I don't have a system put in place to red flag that this.
So whose fault is that?
Is that?
Whose fault is that?
I didn't say who, huh?
Whose fault is
Whose fault?
that?
It is, you could say it's my fault,
Oh,
but
okay.
I didn't do that for 35 years. I didn't.
The judge begins asking direct, precise questions that leave little room for escape. The simple issue of renewing a certificate every 2 years becomes a major turning point. The landlord's reasoning starts to sound more like excuses than justification. Claims of being busy or unaware fail to convince. The judge reframes the situation clearly, placing responsibility where it belongs. This is where the dynamic shifts noticeably. The landlord is no longer controlling the narrative. A reluctant admission of fault begins to surface, and that moment is crucial. It signals a loss of credibility. From here onward, the case becomes much harder to defend.
Because the city and the townships will send a letter out saying it is time to renew your C of O. That's the red flag, or that's the flag and notice that I normally get. I've been used to getting that from the municipality of Pittsfield or City of Ann Arbor.
Okay.
Should I be burdened because they didn't do their job?
I don't know that. I don't think you're reading that correctly. If they don't send notice, then anything they do as to you, you might have a claim vis-a-vis you and the city or the municipality. The ramifications of that not happening still fall to you, particularly where every 2 years your certificate of occupancy expires. So the 6,231.01, why shouldn't that be credited to Miss Norman?
Well, that issue is not before the court in this case. That was resolved in the previous case. We had a consent.
What was resolved?
The previous case had to do with money issue and possession. She vacated the property.
While that case was going on, right? She vacated the property.
That's right. She vacated the property, based on that consent judgment. The other issues on that consent judgment, included, money in escrow, to pay, for a water bill. That money was split between us. And, that resolved, the issues that were before the court at that point in time. You know, when this case was first, uh, brought before this court, in Judge Barnes' courtroom, she had brought this up about this previous thing, and that, Judge Barnes stated that, we're not going to re-litigate the previous case.
And that's
And
fine. And that's fine for Judge Barr. That can be his ruling. That may not be my ruling.
All right, well, any issues of that money should have been brought up in that case. That case, if that was still a problem, or if she's claiming that she had a $3,500.
Why would I issue a judgment if she might be entitled to an offset?
I'm not sure. She should have brought up that she had a $3,500 deposit, which was not the case. That previous case resolved all the issues on that. One of the issues, in that consent judgment stated there might be additional damages, because at the time she still had possession, and I didn't know what those damages might have been at that point in time.
How much was your security deposit?
$3,500.
How much were your total damages?
The total damages,
Yeah.
$7,138.17.
So if she had a $3,500 security deposit, then we're really talking $3,500 at most here.
I don't believe she had a $3,500 deposit paid. She had paid
How much are you claiming her security deposit was?
$1,050.
You have that in a separate account.
I know.
Why?
I don't believe I'm required to have that.
Oh, absolutely you are. That security deposit is not yours. So maybe instead of reading some Supreme Court case about something that is not tangential to this matter, you ought to look at the landlord tenant statutes here, which would require you to hold that money separately because that money is not yours. That money is the tenant's money.
I agree.
Well, I'm glad. So where was that money held? When she paid her security deposit, where did you put that money?
Into my banking system, my banking,
I don't know what that means.
into my bank account.
And you used it.
Not specifically, I had it stockpiled in my bank account.
So how do I know how much her security is?
What I submitted to the court about her payments.
I'm going to repeat my question, so maybe I'll get an answer. How do I know what her security deposit was?
How do you know? Well, what's listed in the lease is not the amount that she paid at move-in.
What's listed in the lease?
The list in the lease was $3,500.
Yeah.
But she did not pay that when she moved in.
How do I know that?
Because the records of what she showed she paid.
How do I know she didn't pay it? The lease says she paid it.
The lease does not say she paid it. She does not have a receipt for that. I do have a receipt that shows she paid $1,000.
Realize how much of a difficulty you're creating for yourself by having taken that security deposit and not placing it in a separate account and holding it in trust for the tenant. And then ultimately using that security deposit, presumably for damages to the premises. And it's unclear to me that you even followed the statute regarding that. That was a question. Can you understand how much trouble you're in? I don't. You're trying to tell me that she doesn't. The lease says it's 3,500. You're trying to tell me it's something other than 3,500. You don't have whatever monies were the security deposit in a separate account.
The discussion moves into the handling of the security deposit, and things quickly become unclear. There's no separate account, no proper tracking, and conflicting numbers. The judge's tone becomes more direct and less patient. Repeatedly asking, "How do I know?" highlights the lack of solid proof. Every explanation from the landlord seems to deepen the confusion instead of resolving it. This is a critical moment where procedural mistakes turn into legal weaknesses. The court is no longer just evaluating claims, it's questioning credibility. The landlord's position starts weakening rapidly. Control of the case is slipping away.
And want this court to just take your word that that's what she paid.
We have a receipt showing what she's paid. There's a paper trail of what she's paid.
That you applied the money however you applied the money. Right?
I applied it based on what the terms of the lease call for.
Well, the terms of the lease call for $3,500 security deposit. Why didn't you apply it there?
Because she did not have enough money to cover the $3,500 when she moved in. She only paid the $1,050.
Does it? Do you have something that says that writing between the parties?
The lease states, I don't have it right in front of me, but the lease basically states that money is applied to late fees, rent, and
I understand.
And that's what we
The
agreed.
last thing, security deposit. But if she's paid $6,231, why didn't 3,500 of that go into the security deposit?
Because when she paid that money, she was behind on her rent.
So how do I get the $1,000 some odd dollars into the security deposit?
How do you what?
How do I get that 1,050 or whatever you're saying is security deposit?
How do you? I'm not.
Yeah, how'd that get there?
Well, how did it get there? She paid me cash, and I wrote her a receipt, and we both signed that receipt when she paid that money
For the security deposit.
towards the security deposit.
Was that what the receipt says?
I believe it does. It's Uh,
Hospitality. Where are they? Hey, you talk to me. I'll talk to Patel. I don't want to talk to him.
Didn't tell him that.
You did tell him.
what am I gonna do somewhere again?
Okay. And then when he goes, they have enough for all of us. It was. Hey.
What?
Well, don't it? We're doing. Okay. This is gonna be a minute, huh?
It is,
You got it?
yeah.
Yay. What's it say?
Uh, It's just deposit at the address, is part of the deposit, which is $1,050. Susie Norman, cash, and we both sign it.
Says part of deposit.
Part of
When is the next payment? I'll just take it you're right.
it does not say, that was not written down in this agreement.
When's the next time she paid you money?
Um, uh, list of payments,
His name is Thornbrook. She left. I don't want her leaving. She.
uh, so she paid that money on, 3/23. The next payment that she made was on May 1st,
Of how much?
2000.
You have something different?
I do have the ledger that he sent to me, as well as the ledger that he presented to the court, which is a little different.
In what way?
Um, this one is the one that he sent to my email is more comprehensive, and it shows that I was paid $2,230 every 2 weeks. I'm a nurse and I was in traveling. My son went to look at the house. I put $4,000 into his bank account at Comerica while I was there in Muskegon. I believe it was Muskegon at that time. Um, and he is correct that $1,050 I paid in cash when I got there. Rent is $3,300. So there was $700 over to go towards the security deposit. Plus, when I got there, I paid him $1,050. So I had paid half of that security deposit, half of the 3,500 with those two totals, that extra that I deposited to his bank and then the cash. Yes, and to get caught up on those payments, I was paying $44.60 a month. And I have received, I have
Caught up with the security deposit.
to get caught up on everything because it just seemed like.
Can I see that ledger? The ledger he sent to you. Show it to Mr. Sanford. Do you recognize that?
Yes, this was part of, we were trying, like you said, trying to get,
Do you recognize it?
yes.
Thank you. Okay, so Ms. Norman, from this, what am I supposed to make?
He continually said that I only paid $1,050 towards that security deposit, which from
Right.
my standpoint, that is correct.
And you believe you paid the whole 35?
I do believe I paid the whole $3,500, yes. At some point, monies went into escrow here when he brought me to court, so there's that as well.
You left the forwarding address.
I did. With Mr. Sandberg and with Jay Mukherjee, who was his attorney.
And was there a list of damage sent to you?
I do have a list of damages that I do dispute.
Right. Did you notify them that you disputed it?
I believe I did. I've answered every.
Well, where's the notice that you received? Who has a copy of that?
I at least have one copy.
Well, I need the notice that was sent regarding the damages in an attempt to apply the security deposit, regardless of what the amount is.
I believe it was his.
Do you have a copy of the notice you sent?
I do. The this is a copy here. So pages, you wanna see that?
If that's a copy of what you sent, can you show that to Miss Norman? And then
I have that, yes.
that's what was sent to you? Let me see. So If you supposedly already took the security deposit, why are we here for 7138.17?
That was the damages of when she moved out.
Because you've never returned her security, even your number that you have for her security.
No, I did not return.
So how did that get applied?
That applies on those numbers that I quoted to you earlier.
What numbers?
Pardon me?
What numbers?
They're written on the bottom of that first page in red ink.
I see that. Let me try my question again. Even by this, the full amount of your claim would be $6,088.17.
That's correct.
Can you point the lease provision that then says it's applied to the security deposit last?
Say again.
Point to the provision in your lease that says it's applied to the security deposit last.
Yes, I have something here. You can
Is that the lease provision?
this is a copy of the lease. This is from the lease.
I don't know what that means.
What he's got is the how the money is applied per the lease terms.
Go to her. I'll take a look at it. What page is it on in the lease?
Well,
What's the number of the paragraph? Can't do this.
It's paragraph 5, application of money from tenants. On page 2 of the lease.
Can't do this.
What part of that?
All of this. So when she pays money, the fifth thing that it gets applied to is rent. That was a question.
Yeah, that's what
So, so if that's the case, if this, why wouldn't the 1,050 that you acknowledge she pays be applied?
can you say it again?
Why wouldn't the 1,050 that you acknowledge that she paid you in cash, why wouldn't that be applied pursuant to this provision?
It is applied, it's a deposit.
Yeah, but no, there was nothing else owed when she gave you that money?
Oh, there was something. The difference between that and,
Why wasn't the 1,050 applied pursuant to paragraph 5?
it was.
There were no late fees?
I did not charge her any late fees. I waited all the late fees and any other fees.
No, at the time she gave you the 1,050, why wasn't it applied as contained in paragraph 5? Which, by the way, me asking that question, I think paragraph 5 is highly illegal, but go ahead.
Um, when she paid that money, that was right when she was getting ready to move in. And that went towards the security deposit
Why didn't it go to rent?
because she had paid the $4,000 prior to that. They covered the first month's rent. So she did not have late rent at that point in time.
I see. So then when she paid these extra monies, you just applied them in this way, applying them to rent last, basically.
Well, I can't remember what the numbers I got on that. It was applied to rent last, but there were no other. I was trying to work with her. I did not charge her any late fees during the whole process that she lived in the house.
So why weren't applied to maintenance and repair costs chargeable to the tenant? There was none of that.
No.
Third, outstanding legal fees or court costs.
No.
And utility bills, there were none. But there were.
Later there was, but it was not applied to any of those.
Ms. Norman, what would you like to say regarding this?
I would like to say that I entered into a lease with him for 17 months. My family, we were planned on fulfilling that lease. There were issues with the property, again, which led me to no leaks prior to tenancy. I just view these damages as incredible labor charges. And that's where most of this is coming from. At $100 an hour. And he wasn't supposed to even enter into a lease with me. I deposited that $4,000 on the day that his lease expired. I know that he had some questions about when that was done, or some comments about that.
When did you move out? I'm sorry.
October 31st on Halloween of 2024.
Gotcha. Okay, go ahead. I'm sorry.
So I know that this case is a damages case. But I think first and foremost, I paid him over $15,000 in rent. I have receipts, I have money orders showing that. I tried to do everything that he asked of me. almost paying like $4,500 a month to get caught up on everything. Here we are, in court again, and these damages, I just want to address them based on the report that Mr. Frank Daniels gave me, and some of these things he has as my fault, like a leaky bathtub and water. He's charging $800 for chalkboard and writings on the walls, but $75 for solvents. He's charging for 2 doors at $100 an hour for 17.75 hours. The materials were 211, but the labor is almost $1,800. Cost of screen repairs, $100. I have pictures of this. It's just things like this. This leaky bathtub. If you look at the report, it has water intrusion listed. And when I came to sign the lease, I saw garbage bags stuffed into the walls, between the wall and the floor in the basement. And Mr. Stanford let me know that there was water intrusion leaking into the basement. I have texts and I have pictures of those garbage bags. He made me aware that DTE was coming to fix the water issue. I don't know what DTE has to do with the water intrusion, but that was what was in the text between him, himself and me. But yet here I'm on here for all of this plumbing repairs. $1,200, $167, $425. This property had multiple issues, and I only wanted him to repair them. And it was, I have to do research. It was just a lot of that. And I stopped paying rent and I put it in an escrow here for your order. And then we came to court for these issues. I eventually moved out. I sent him the information, the address. I tried to just move on, and then, we circled back to now I owe $7,000 in damages, even though that water intrusion ruined my granddaughter's clothes, my grandson's clothes, my daughter's clothes, because there was a bedroom down there. I didn't pursue any of that. I was just trying to get some closure. I had to go back and secure another place to live, pay more deposits. So I was trying to get him to repair things. And then when I found out all of these issues were wrong, I even hired an independent electrician to fix the electrical issues cited in the ordinance from Mr. Daniels, just so we can live properly in the house. The house was not inhabitable.
Of those list of damages,
Pardon me?
of the list of damages that you got, do you think you owe anything on that list?
I do not.
Okay.
I do not.
So, sir, where can I see the list of damages? That I gave it.
Maybe on this page.
Your Honor, can I respond to
No,
comments?
no, you'll answer my question. $1,090 is the Holloway fee. $1,090 is the Holloway fee of 10 hours. Who is doing this labor?
Two of my people that work for me.
Are they here today?
No.
And how do I know they did it?
because I'm testifying that, they did.
I want to know what they did. This is trial.
Well, what they did, if you look at the,
Okay. If I said I want to hear from them, you telling me doesn't tell me that. What kind of who put the blinds up?
me and my crew,
How many blinds?
I think there are about 11 or so.
The blinds were $10 then? Or how do I read that cost for blind replacement?
Let me get that up to you. Um, uh, Cost of lines was $111.35, and $250 labor.
We have the receipt for the blinds?
I believe I do.
Okay. And what was the $250 labor?
That's the time it takes to install those.
Install how many?
I believe there's 11. There's a photograph showing the number of boxes in a trash can of how many, blinds we
I
think.
don't care what's in the trash can. How do I get to $250?
When, we signed the lease provision says, we agreed, that, repair bills, Stanford Enterprises would, do that work at $100 per man hour. That was the agreement that we had. And the amount of time we had on the blinds is what's, listed in this,
So how do you arrive at 250?
I look at how many blinds there are and, you know, figure out what the amount of time that my crew worked on this. You know, it took us a month to get this house back, ready to rent again. It was, well, you've seen the
At
pictures.
this point, I could care less. I'm trying to figure out how do I get the cost to install these blinds? Who did the work?
Two of my folks that work for me,
Are they here?
they're not. One of them moved to California.
Cost of replacement doors installation. Who did the work?
The fellows that work for me,
Are any, in terms of any of the costs that are on here, are those people here today to tell me that they did this work and how long it took them?
no.
So how do you presume that if the people that did the work are not here, that I'd be able to sustain your claims?
This is the, um, this is the cost that it cost me um, to make these repairs, the newest repairs in this house. And I'll testify under oath. I swear to tell the truth, the whole truth, and nothing but the truth.
That's fine, except that you didn't do the work.
I supervise the work. I was there on a routine basis.
Were you there doing the work?
Pardon me?
Were you there doing the work?
I was not doing the work, or I was doing some of the work. They were doing some of it also,
How do you know how long it took them?
because I have all their work orders that are their payroll documentation that they.
Have you supplied that to?
That's how I came up with these numbers.
Not my question. Have you supplied the payroll documents to Miss Norman?
No, I am not.
So how am I to know that that's what you paid them or that she knows? And for what particular work?
This is basically an invoice.
There's this self-dealing because it's your company that's doing the work.
That's true.
And so you're charging her that, and there's no way to check whether these people spent that time. You could put whatever you want down and provide whatever receipt you want because it's your company. The only check against that is to have the people that did the work testify. And they're not here. What happened to the old locks?
They were discarded.
What was wrong with the old lock?
I did not have a key to it. She did not return keys, and I had to replace the locks.
Or get a key made?
Pardon me?
Or get a key made?
I,
Or get a key made?
well, I could get a key made, but from a security standpoint, when I have a conflict with a tenant, I always change the locks on the
Fine.
house.
You don't throw them away, do you?
I do. You know, I don't want to use those locks again with potential problem, somebody coming back with the key from a security.
So who installed the locks?
I installed some of them.
How do I get to 2.5 hours? Is what I want to know.
That's what it took to put the locks.
Was that you at 2.5 hours, or was that other people at 2.5 hours?
It was me plus the other fellows. There were
The ones that aren't here.
2, 3, 4, 5. I believe 5 locks.
How many doors did you replace?
There were 2 doors that were replaced.
Are these outside doors?
No, they're interior oak holocore doors that were totally missing when she moved out.
And it took you 17, almost 18 hours to install 2 doors?
Between ordering those doors, buying those doors, delivering them to the job site, getting them hung in an existing jam that might not be perfectly.
Oh my goodness.
And then
Got to be kidding me.
no,
You don't get paid for that.
I wouldn't have to be doing any of that work if she had not.
You
Hey,
wouldn't hear if you had gotten your COC, because the work wouldn't have needed to be done because Pittsfield wouldn't have let you rent it. So what if? How do I break apart those dollar amounts?
I've been a licensed builder
I don't care.
47.
I don't care. I don't care. How do I break that apart?
What needs to be broken apart? This is my testimony that it's what,
How many? There are two doors. The doors themselves cost $211.47, according to you,
yeah,
and $1,800 to install.
at $100, so yes.
Okay, so here's what I'm going to do. For every one of these things, I need you to write where there's this labor cost. What's this? The last thing on here, cost of carpeting, drywall, and painting, $1,200. What is that?
But let me address.
No, you'll answer my question. What is that?
That is the cost of doing carpentry in that basement, replacing drywall from a water damage that she or somebody in her family caused, and repainting in that basement area.
Is that, but that one's not broken apart. That's just a number that I have here. I don't know what that means, that 1,200.
That represents the amount of time and effort and materials that went into correcting that problem that her family.
How is it broken apart?
Well, there's material, there's labor, and that's what it takes to put those repairs back together again.
Okay. Of the 1,200, let's try it this way. How much of that's material?
Material generally is about 35 to 40% of the cost of places. Depending on the type of product we're installing.
Okay, let me try this again. The last item on this sheet says cost of carpentry, drywall, and painting. And it says $1,200. Unlike the other ones that at least try to list time, and I'm not sure whose time, this lists no time. It lists no material. It's just a number. So where did that number come from?
That came from looking at the timesheets that my fellows turned in, working on, there's carpentry aspect of it. There's drywall. They're going back and forth. The drywall takes usually 3 coats and you got to let it dry in between, and then painting after that, after it dries.
So where's the cost for the drywall?
It's included in cost of carpentry, drywall.
Why is everything else broken apart, but that one's not?
Well, the amount of drywall on this was not a large amount. The majority of this one is probably more on the labor end of it, because that type of repair is labor intensive. And that was a damage that her family caused. You know, there had been a bathtub that got stopped up, and I got the call one evening that a
That's
bathtub.
a whole lot of self-dealing.
What's that?
This is a whole lot of self-dealing on your part.
Uh,
Oh, yeah, it is.
I,
Oh, it is. It's been disputed.
I,
This is a lot of self-dealing. I don't have independent anything to try to verify this. Nothing. Well, I'll tell you what. Let me hold this for a moment if I could. I'm gonna take a break from this case because there are other people I got to figure out who's ready, and I can handle something else quicker. You need to figure out how you're going to get this testimony in because I'm going to come back. We're going to continue this. I'm going to swear people in, and I don't know how you're going to sustain your damages here.
are you saying we're gonna?
No, I said what I just said. We're coming back. I'm going to swear you in. I'll have a trial. I don't know how you're going to testify about something that's hearsay because I'm not allowing it. So you can then figure out what you're going to do. On this, I would suggest if the parties can talk, that they try to talk about resolving it. But if you can't, then I'll do it. That's what I do. Thank you.
We not reach a courtroom, or what time should we meet then?
I don't know. My watch died. It's 11:15. Why don't you do this? Why don't you come back about 12:30 or so?
12:30.
12:30 or so.
Thank
All
you.
right. Folks, I know the rest of you have been waiting. Give me about 5 or 10 minutes. I'll come back. Maybe, I'll come back and then we'll start trying to resolve it. Miss Dornbush, were you? She needs settlement. Okay. Gotcha. Okay. And then Mr. Hamden and so you're not, you need to talk to me also. There's only one of you that I want to talk to. All right. I'm not gonna say who. Just saying. That's the only other one.
So I'm gonna only have tenants like
You don't have the plaintiff? Okay, let me try to deal. Take a look. Court calls the case Fixing Housing 401k Plan LLC versus Erica and Aaron Ward. Appearances.
Gil Stanford.
Susie Norman.
All right. Why don't we do this first since we're about to begin trial? Why don't I have the parties sworn in?
Yes. Raise your right hand.
Oh, yeah.
You solemnly swear in front of the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Gil Stanford.
Do you solemnly swear in front of the testimony you're about to give will be the truth, the whole truth, so help you God.
I do.
State your name.
Susie Norman.
And this is Stanford, this is your case. So you may give an opening statement, sir.
Okay. This was a lease. The lease date was 3/25/24. Starting and the ending date was 8/30/25. The rental amount was 3,300 plus utilities. And there was a partial deposit paid of $1,050 on 3/23/24. She moved out on October 31st, 2024. This there was a prior case for this, and that was a case that involved primarily two things. It was possession case and non-payment of rent. The non-payment of rent was waived, and it came down to a possession case. That case was negotiated to a consent order on that to an agreement, and she was going to move out on a certain date, and there was money in the escrow account, and that was going to be split to help pay a water bill, and the remaining dollars would be returned to her. She had a case counterclaim that was dismissed, and in that consent order, there's a statement saying that the let me quote it, the defendant may be liable for money damages if additional rent is owed, if there is damages to. And this case today stems from additional damages, and the dollar amount right now we're talking about $6,088.17.
But that's amount presumes the number one rightful withholding of the security deposit and your assessment of the amount of the security deposit.
Say that again.
That amount you gave is based upon what you are saying the security deposit paid was,
Correct.
as well as whether or not that security deposit was rightfully withheld from the damages.
Let me restate that. The damages were $7,138.17. I applied a deposit of $150 against that, leaving the balance to $6,088.17.
Ms. Norman, you may give your opening statement.
Your Honor, this case concerns the condition of the rental property during my tenancy and the claims have subsequently been made against me. The evidence will show that the property has significant documented deficiencies, including conditions identified by the township inspector and issues relating to the property's certificate of occupancy. The evidence will further show that these conditions were known during the tenancy and were the subject of communicating partners. I will present inspection records, photographs, communications, testimony regarding the condition of the property and the circumstances surrounding my tenancy and the damage now being claimed against me. I believe that the evidence will show that the claims against me are not supported by the facts, and that the property is an important part of the court's consideration in this matter. At the conclusion of the case, I will respectfully request the return of my security deposit, reimbursement of my staff, travel expenses, any costs permitted by law, and such other as the form deems appropriate based on the evidence presented.
Oh, thank you. Sir, what did you want to tell me about the case? You don't have to ask yourself questions. I may have questions regarding it, but let me, well, before you start, was there a move-in checklist?
Yes, there was.
And you have it?
You should have a copy of it there.
Do you have a copy for the court?
I do.
Let me see the copy that you have and then show it to Ms. Norman and then to the court.
Uh, the first copy is my beginning, when she moved in, and second copy.
Or what?
Pardon me?
The first copy is what?
There's three copies here. It's my copy of the inventory sheet that I fill out, and the second copy is her, what she filled out.
Show that to Miss Norman.
Yeah, I have it, Your Honor.
All right. All right. Go ahead. What else do you want to tell me?
So in regards to the previous case, what she had said this morning, at the hearing, she thought the whole, case was settled. She thought that was everything. And after that, there was no appeal within that 3-day window. Money was paid, in that prior case, into escrow. And that money was distributed to myself and to her to cover, water bill. And this case, the only issue is, in regards to money for deposit and, that against the damages. I believe it would be inappropriate to open any issues from that prior case in regards to payment that she's made. We both signed the agreement, of the consent judgment, and that was approved by the court also. So I think the issue here is clear. It's, the damages, that I've documented, and the amount that she paid, that we have a receipt for. The deposit was $1,050, not the $3,500 that she's claiming.
Go back, and if that's all that you have, I want to go through the damages again. The original security deposit charges that you sent claimed rent, right?
I did not hear what you said.
Your original document regarding the security deposit and claim for damages included on that rent for the months of November and December in a total amount of $6,600, which was well after the judgment that was entered, right?
Yes. I believe that's, that original one included that month of November.
Which was not chargeable pursuant to the agreement.
I mean,
Which is not properly chargeable pursuant to the agreement.
That's correct, and that's why this,
Well, that's why it wasn't chargeable, correct?
correct.
Then it comes down and it says cover the cost of damages, haul away. And then the dump fee. You have $1,090. How do you arrive at that figure?
You have that paper in front of your face, I did. here. Oh, yeah. What was that, your question again?
The first list of damages you had covered cost to cover damages, haul away or haul out and haul away. You do 10.25 hours plus 65 dump fee, and you come to a total of $1,090. How do you calculate that fee?
How do I,
How do you calculate that fee?
$100 per hour for the labor and,
Who did the labor?
pardon me?
Who did the labor?
It was myself and two fellows that worked with me,
So how much was being charged per hour?
$100 per man hour. Like the lease call,
So $300 an hour.
What?
$300 an hour.
if there's three people working.
Well, that's what you just said.
Well, there were three people working at it.
So is that what was charged here? I'm trying to figure out how I get to this figure.
It was $100 per man hour. There were three people working. And it was just,
So that's $300 an hour.
you want to figure it that way, yeah.
What do you mean if I want to figure it that way?
Well, the lease.
I don't care what the lease says. I'm trying to figure out who's there.
It was myself.
So if there are you and two people, that's three people.
Right,
You charge $300. You charge for each person $100 an hour.
correct.
So how long did each person work?
How long my hearing is not that great, and you got your head down. How long is what work? How long do we work at that?
If you need hearing assisted equipment, we can get it for you so that you can hear my question.
That'd be good. All right.
Cost to cover damages. How was that 1,090 calculated? How many hours did each person work?
We each worked about 3 hours on that. I believe this is one of the math comes out to.
Well, about 3 hours, or you work 3 hours?
Well, it would be, I think it was, well, I had a total of 10 and a half hours
I see what's there. I can read.
between
What I'm trying to figure out is what did each person work?
uh, each, I don't know, I don't have the exact breakdown of that right here of each, what, between the three of us, it was, 10.
How do you get that if I don't have an exact breakdown of what each one worked? Because you're charging per man hour.
Right. And I had,
So if there's two other people there, there's you, and then there's a worker and another worker. So how many hours did you work?
I worked about 3 hours on that.
Worker one, how many hours did they work?
The damage claims are examined closely and they lack proper support. There are no witnesses, no verified labor records, and the costs appear inflated. The judge openly calls out the issue of self-dealing, which is a major blow. Without independent verification, the claims lose their strength. Even basic breakdowns of costs cannot be clearly explained. The judge's frustration becomes evident as the answers fail to meet expectations. What began as a strong financial claim now looks unstable. Then comes the turning point: the case is paused due to weak evidence. In the end, doubt takes over where certainty once stood.
3 1/4, 3 1/2, I'm not sure exactly.
And the other worker, what'd they work?
Around 3 hours, 3.25 hours.
What proof do you have that they worked that time?
Well, I have all their payroll documentation that they noted on what they did and how long they worked at.
Where do you have that with you?
I do not,
And the person's not here.
no.
So the only thing that I have proof is your testimony of 3 hours.
Well, yes, of what I worked. And I'm testifying that they also worked, and it was a total of 10.25 hours.
But they're not here to testify what they did.
And I'm testifying that what,
I hear what you're doing. You can argue with me all day. They're not here.
right, they are not.
The blind replacement. What was wrong with the blinds?
If you look at the pictures that I submitted, they were all damaged, missing. The slats on them were all damaged and in just
Which particular photos?
uh, uh, well, photo number 1 shows 2 damaged blinds. Photo number 2 shows a blind missing.
So that's 2 blinds.
Photo, yeah. 4 shows a blind missing.
Well, I don't know what photo number 4 is. Because these are all different windows.
These are all different windows, yes.
So I see a close up of a blind. I then see, and I don't see damage on photo 14. So in 13, I see damage to blinds. On photo 14, I don't see damage at all.
Right in the very center of that slab has got a crack in it.
All right. Then on photo 18.
Yeah, you can see there's several slats that are missing.
Photo 19.
A slat missing out of that. That was on a door.
Where are the other ones?
Um, Photo number 42 shows all the boxes and how many blinds I've.
That's fine. I'm looking for damages. I did. Where's the damages?
Well, like I say, photo 1, there's 2 there. One, an additional one on photo 2. An additional one on photo 4.
Where on photo 2 do I have blinds?
It's a window, and
I see that.
there's no blinds on that. It's missing. There were blinds there when she moved in.
Would you agree with that? On photo 2, that there were blinds in all the windows?
I don't agree with that damage claim.
Not asking that.
Okay.
Photo 2 says missing blinds. Do you agree that that blind is missing?
I'm trying to photo.
No, it's okay. Which photo are you looking at, man?
This is 5 and 6, 7 and 8.
Got it. But the one right, do you have a picture right before that? Or the first one, maybe?
Mine starts with 5 and 6, 7, 8.
Gotcha. So look on the very back, do you have one?
I do not. These are individuals.
Got it. Mr. Can you do this from, I'll need it back up here, but. Can you show her that one? You see 1 and 2?
Yeah.
That's okay. Did in photo 2, was there a blind in that window?
There may have been a blind in that window. The one with the curtain on it.
Yeah.
There may have been a blind in that.
Okay. All right. Fair.
You're on, all windows have blinds. If you look at my storage sheet, each of those rooms, indicate window and blinds detail, and it shows that.
I asked her, was there a blind? She didn't say no, there wasn't a blind. She said there may have been a blind.
Oh, I know, I'm just saying that.
Well, I know what you're saying, but I got her answer. I have your answer. So I count 3. 4. 5, 6, 7, 8. I count 8 blinds most.
That's what.
And I'm not sure photo 13 and 14 are the same blind.
Uh, um, no, those are not. That,
All right. How much were the blinds?
the blinds were $111.35.
Do you have a receipt?
I do not.
How much were they each?
They are about $10, $12 a piece, depending on the size, usually.
But you have no receipt for those.
I did not bring it.
Okay.
When I compiled all this, I put it into this document. Those.
Cost of obscure spray removal. Oh, what is that?
If you look at picture number. Picture number 37. The living room window had something on it. Bathroom window had something on it, sprayed to make it obscure.
Miss Norman, did you put something on the window? You did. Okay. How long did that take to remove?
I don't know.
Screen repair and installation, 1 hour?
Yes,
How many screens?
I believe there were two that needed attention. There's a picture of that. Picture number one. And, and here, there's, screen missing. Number 8. And, picture number 8 and 9, same, a window there.
Cost of replacement doors and installation. How much is actual labor?
The labor was, $1,775.
That wasn't labor to put in the doors.
That was the labor to return it to the condition, when she took possession.
I don't know what that means. You talking about replacement doors, where are they in these photos?
Where are they?
In the photos, what numbers?
Okay, number 6 is, the front bedroom. There was no door there when, I took possession of it. And there is a photo number, photo number 50, what happened in the master bedroom. The door was completely missing.
Is Norman, you see those?
See. I see them, yes.
Were those doors removed?
That would be,
You,
I did not remove them.
were they there when you moved in? Were they there when you left?
No.
Okay, so who do you think removed the doors?
Could have been anybody. We were moving out and there were scratches on the door.
Okay, I got you. Do you have a receipt for the doors, sir?
I do not have that.
How did we calculate this 17.5 hours?
That's the labor that it took to, get 2 doors hanging in those 2 openings again and, sealing them with.
When the doors are on the premises, I cannot believe I have installed doors. There's no way it takes that long to do a door.
The doors were not on the premises. They were completely gone. I had to buy new doors.
Okay, I get you, but when you have doors there to put up, it didn't take 17.75 hours.
It did.
Explain to me that whole process that took 17.5 hours.
Okay, these are 2-bedroom doors. The front bedroom door is 30-inch wide, 6'8" high. The bathroom door was probably a 28-inch wide, 6'8" high. They were oak doors, oak hollow core doors. I needed to go and.
But I don't have. But again, I don't have the receipt for that.
No, I don't have a receipt other than what I've got written here. This is the receipt.
Where did you go to get the doors?
I ordered those from Home Depot So I had to order those. It's not a stock door. I had to make another trip back to pick those doors up, deliver them to the site. You have to bevel the edges. You have to drill the hole for the lock. You have to mortise the hinges into the door.
But I don't know if you brought, I can't tell from this or anything that you have, whether you bought pre-drilled doors or you bought new blank doors.
A new slab is what I bought.
I can't tell that because I don't have a receipt.
Well, my testimony is it's a blank slab.
I hear that. But you're telling me that, but I don't have a receipt for the doors you purchased. Right?
Right.
Once the doors were on the premises, how many of these hours were spent putting these doors up?
I would say probably about 15 to 16 hours.
To do two doors.
To plane them, cut them, reseal them. You know, 3 coats of polyurethane on it.
Two doors.
Yes.
Did you do all that yourself?
I had one of my carpenters do that.
And how long did they work?
They were about 16 hours on that.
So you didn't do any of this?
I delegated it to them.
So where are they to testify that they spent that much time on these doors?
They're not here. I'm testifying that that's what it costs to replace.
You watched them do that for 16 hours?
Yeah, that and their
You
time.
watched them for 16 hours?
I was on the job site when this was happening. I wasn't.
Did they do anything else?
No, that I had.
They did just the doors.
Just the doors. That was the task that I assigned.
But they're not here to testify. Because I'm finding that hard to believe.
Well, and what is the testimony that says that it should be anything less?
Well, I'm finding it hard to believe that you spent 16 hours on two doors. Where I don't have the receipt for the door. I don't know whether they're pre-drilled. I know nothing about these doors. Nothing. Why don't I have the receipt for your materials?
I didn't pull that together when I wrote this up. When I wrote this up, I think
Then where did the 211.47 come from?
that is the material for the doors and polyurethane.
So where's the receipt that backs that up?
Where is that? That is in my office.
Cost of new locks and labor to install. Which locks are these?
There's 4 locks to a garage, 2 garage doors. There's 2 locks to a back door, and there's 1 lock to the front door. They're all exterior locks or exterior doors.
Do I have a receipt for those?
I do not.
Do you have the final water bill?
I do.
Do you have it with you?
I do.
Have it your own.
If you want to help them, that's fine. What? Yeah, what does your final bill read?
This was sent to me by Cindy at Pittsfield Township. I called her personal.
When?
I have to check my email, but it was not too long ago.
Okay, no, that's fine.
Yeah.
So
This is. Here is the bills that are paid. Um. This is not the big one that she had. Oregon. Here it is.
Beautiful.
no, just give me that one right now. So when this doesn't tell me the final bill.
Well, there's something under 1,500 and some dollars.
Your sheet says $131.89 for a final water bill.
Well,
Well, hold on a second. But the water bill was taken care of in the last case.
the large portion of it was.
No, clearly the transcript says for the water bill.
Um. The, the escrow returned $1,500 to me, for the water bill. That did not pay the total dollar amount of that water bill.
Okay.
There
So,
was some additional.
so then there's $81.89, which you're saying is owing in excess of the 1,500.
I believe those are the numbers.
And then you're going to charge a $50 administrative fee.
That's what the lease calls for.
No. All right. So
I
if anything, it's $81.89. But the way I read that last case, you got $1,500 for the water bill.
towards the water. Oh,
That's not what it says.
Well,
Cost of fridge drawer, which
there is that it is. Sure, no. Number 39. You can see the crack on the front face of that drawer.
$127 or basically $126.89. Do you have a receipt for that?
I don't. It's outrageous what these companies charge for replacement parts.
There's some landlords.
And
So do you have a receipt?
I do not. And there's no labor involved with that.
Shocked. Cost of writing on walls, floors, chalkboard, and furniture. 8 hours, 75 for solvents and paint. Do you have receipts for the solvent and paints?
I do not. That was some materials that I already owned. So I don't have a receipt where I went out and bought that, but that was
So how did we charge 75?
because I took probably a gallon of paint, solvent to get that out of there. You know, if I had a job like this, I'm not gonna run up and buy every little 4 screws for this, 2 that.
Yeah, but at some point it's charged to a job and not 50 billion jobs.
Well, it's part of my inventory, so that I'm well equipped to go and do this without running to the store.
Who did this?
I did some, my helpers did that some, and I hired a lady to come and do some cleaning also.
None of those people except for yourself are here to testify?
That's correct.
How do you come up with the 8 hours?
That was what I looked at from the hours by my crew and my notes from what I put in.
Do we have that?
I don't have all those details of that. I could overwhelm you with that kind of paperwork if you really wanted it, but
This is your case. I don't get overwhelmed easy. So I don't. Plumbing part of repairs.
okay. That
$425.53.
let me expand on what she said this morning in court in regards to the plumbing issues on this. She had mentioned plastic bags under a wall and a leak in a basement. That was from a previous tenant who had put plastic bags underneath the wall because there was a leak in the front corner of the building where DTE replaced the gas line. They replaced the gas line and damaged the foundation waterproofing. Shortly after she moved in, I finally got a hold of DTE and got them out there. We exposed that foundation and corrected that water leak. It was a real random water leak that would come in one spot right where the gas meter was. That was the one issue that she had mentioned this morning. The other thing she mentioned was this leak from the bathtub.
So why am I talking about this? I'm trying to figure out what you're charging here for what.
well, and I'm gonna get to that right now.
Are you going to? Good.
There was she had a bathtub that was not draining properly. Someone in her family decided to make a self-help repair on that. And what they did is they damaged the drain on it. They certainly got the water to drain out of the bathtub. They broke the drain at the bottom of the bathtub, and all that water.
I have a picture of that.
If you look to the back of this, let's see. And, showing the drywall damage and repair, which is, if you look at, photo 24, fire damage over the closet door. And,
And that was caused from whom?
I don't know exactly who, I think it was maybe her son-in-law or the daughter's boyfriend. I'm not sure who actually worked on the plumbing, but they damaged the pipe and basically broke the where the water comes out of the tub.
Did we have a plumber come in to fix that, or you have a plumber come in to fix that?
I did that personally. And what was involved with there was replacing a drain part, a fitting to put that together. If you look at,
It took you 4 hours to do that?
4 hours on the, let's see, plenty period. Yeah, 4 hours on 6/17.
That's why she was in the premises.
Pardon me?
That's why she was in the premises at the time.
She had been in there several months. This was not there when she moved in. This was after she moved in. She moved in March, whatever it was.
I know, but these aren't damages you discovered after she left in October.
No, I was aware of them on.
Then they would have been subsumed into the other case.
No, because I was not claiming damages on the other case.
But your damages pursuant to your lease become part of rent. So if these are damages you're claiming in June, and the agreement covers through October, why are you coming up with this afterwards? Why wouldn't that have been put on her ledger?
Because I didn't finish. She wouldn't let me into the house to do this repair, for one thing.
So did you get into that? So did you do the repair in June or no?
No, I did that after she moved out.
Hold on. You're not telling me the truth because your document says plumbing repair, 4 hours labor on June 17th, 2024.
Oh, okay. I did the repair so the bathtub was operational.
So now you did the repair.
I did that repair on that date. And then
But I thought you said she wouldn't let you in.
I misspoke.
Oh,
She let me in. I did that repair on the plumbing pipe that was leaking, and the drywall repair and the moisture down there. That's what she would not let me come back in to repair. And the drywall repair was all done after she moved out.
caused to dry out moisture. What is that?
This had a bunch of moist drywall and whatnot, and the way you get rid of that is you get product dowel flake, which is
I know what it is.
it's okay, and you put that in buckets that absorb that moisture out of the air, and that's how you dry out a job like that. I had an hour and a half.
But the doubt, an hour and a half of what? Putting it into the bucket?
To go and get the material, get to the job site and set this thing up. An hour and a half involved with doing that.
Cost of carpentry, drywall and painting. I don't know how any of, you just put $1,200. I don't know where I get that.
Well, if you look at picture number 40, you'll see the drywall that's been torn out. And the door that had to be removed, and that drywall had to be patched and repaired, painted and finished.
Who? But that just shows after work has started. What did it look like before? I don't,
If you go back to picture number 24, shows what that looks like after this bathtub leak.
but hold it. All of that was something that you were aware of on the prior case.
Yes.
So why wasn't that assumed into the other case?
Um, I don't know. My lawyer at that time said, you know, to keep this case simple, do possession rather than the damage issues. Oh, and actually, she was still.
But if you had, go ahead, but she was still what?
She still was occupying the property. I didn't have any total, or I didn't have a total of what damages were going to be. So it just wasn't something that hadn't been repaired yet, as far as the drywall.
That's everything from that list. Sir, can you explain to me how you think a security deposit's applied to damages?
How the security deposit is applied to damages.
Yeah.
Well, it is. I understand I have to have a judgment towards the damages to technically apply that or to withhold that security deposit. It's not automatic unless the landlord and tenant agree to a settlement.
Was she billed separately for the security deposit?
No, it was part of the money that she was paying when she first moved in.
So how do I know of the amount she paid? How do I know what is security deposit and what is not?
Um, well, we have documentation of how much she paid and when she paid it. She paid an initial $4,000 into my account, and then at the time she moved in, she paid me $1,050, which was not enough to cover all the costs of what the lease.
Yeah, but why was it split the way that it was?
She made that payment when she was on the west side of the state, and then when she got there.
How come 2,500 of the 4,000 wasn't applied to the security deposit?
This, well, when she paid the $4,000, that first thing goes to rent. According to what the lease terms say, where the money is allocated.
Right. But so if she gave you money, it goes to everything before rent and the deposit.
It does, according to the lease terms, but I did not charge her anything other than rent and a deposit. There are no late fees. There's no any other charges against money that she paid me.
Anything else you want to tell me?
Let me go through the photographs to document the condition that
Yeah, but you're not charging her for that.
I am charging her for the cost of returning it to the condition it was, other than the normal wear and tear, is what I'm charging.
But the document you sent her, this specific thing that I just went through.
Yeah.
So why am I hearing about the photos?
Hearing about the what?
Why am I going to hear about the photos?
Because I want you to understand.
I understand
What
everything.
Uh,
Why am I hearing about them? You gave your delineation of damages for which I have no receipts, which I have very few receipts. I have very few anything regarding it. I don't know what benefit the photos do for me.
help you understand the damages that her family caused to this property and what it took to correct those damages.
I don't need a description of the photos. I went through the photos that I went through. I mean, they're part of what I have here, but I don't know that you sent her a specific list of damages. I went through each one of those damages. I don't know what the photos do for me.
All right.
Anything else?
Well, I think she has caused a lot of damages, cost me a lot of money. And I don't think it's something that she should be able to not cover that cost.
If you handled her security deposit improperly, do you believe that you should, pursuant to that statute, owe her double security deposit?
I don't know that I handled her deposit incorrectly. Can you, what is that part of that statute about the security deposit?
Well, it's a failure to return the security deposit, number one. But the other part is you did not put her social security deposit or her security deposit in a separate account. You didn't even tell her in the lease, the financial institution at which you were keeping her.
That is in my lease.
Where is it?
Um,
But it's not in a separate account. It's commingled with your monies, right?
Yes. It went into, America Bank. The, was it, on number 12, on page 3, name of it, financial institutional deposit, L is America Bank, here in Parkway at Washington.
Is that where the 1,000 went?
Yes,
Into your account,
yes,
not into a separate account.
yes.
All right, anything else?
No,
Norman, anything you want to say?
Yes.
Go ahead.
May I use that as reference?
Which,
The pamphlets,
this?
just to kind of quickly respond to that.
Sure, I'll need a copy of that. We'll get a copy afterwards. I want a copy because
So first I want to address the security deposit. I did, deposit $4,000 into Comerica Bank. 3,300 I thought was going to bring the other 700
went to the security.
security in addition to the $1,050 that I paid him in cash that he, for his testimony, said that he put in Comerica Bank. I continue to make payments to him because per the ledger, he had this payment plan to get everything together, and that was the amount of $2,230 every 2 weeks. I was paying him.
Did you pay that?
Yes, I did. And I have my money orders and such here,
2,200.
and $30 every 2 weeks.
So basically, each month you were paying $4,460.
Correct,
3,300 of that would be rent,
correct.
which means you were paying an additional, well, even on that first month, you would have paid an additional 1,160. Which would have brought you to 2,950 on just the first month, but then you would have been over on the second month. Or after 4 weeks.
Your Honor, that was his solution that he,
Right. No, that's fine. What? Let me stop you for a moment. What happened to the extra money she was paying?
she did, what she stated was what we had tried to put together in an agreement. That's not the amount that she paid. What she paid was on May 1st, $2,000.
May 1st.
2,000, and you've gotten this, a ledger.
Sir, go ahead.
May 13th, she paid $230.01. And then May 28th, she paid 2,000 even. That is all she paid.
Is that correct, ma'am?
I have those receipts. And I also have text messages.
Hold on. Where are your bank records that indicate her deposits?
I believe I have a copies of her, she gave me money orders, or 4 cashier's checks, at $500 each. Is what she gave me. I believe I have a copy of those. See that? But she was, again, when we first started this lease, she was having a hard time getting her money out of her bank the way she was banking, and had a limit on how much she could pull out per day.
Okay, that's fine.
Go to.
So the extra 7, you admitted she paid 4,000. The extra 700, did that go toward her security deposit?
Looking at the numbers now, you're absolutely right. So her security deposit was actually 1,750.
You really have no idea, do you? I mean, that's part of the reason security deposit is kept separately, because that's the tenant's money. That's not the landlord's money to have and or to use till the end. So if that's the case, and now you concede that the 1750, the damage sheet that you sent was incorrect. It was incorrect on a number of levels. It was incorrect, one, because the damage sheet included rent, which you negotiated away during the first case. Then it only gave her credit for $1,150, which, or from $1,050, where there was an additional 700. That again wasn't placed in a separate account. Norman, anything else?
Yeah, I just wanted to hit the highlights on those damages. If
I don't need it.
You don't?
I don't need it. Mr. Allen, could I get this sheet there? Anything else, Ms. Norman?
On that.
No? Okay. I'm gonna take a recess. I'll come back and give you my decision. Thank you.